All right, ready to go? It's called to order. This is a public hearing of the Metropolitan Board of Zoning Appeals, Division 2. I am Craig E. Von Dalen, chairperson of Division 2. The other board members present are Beth Brandon and Kirk Farmer. Legal counsel for the board today is Chris Steinmetz. Staff members present today from the Division of Planning are Eddie Onea, Principal Planner 2, Jeff York, Senior Planner, Robert Unenhake, Senior Planner, Marlene Iraheda, Senior Planner, Genesis Hill, Associate Planner, Heather Stevens, Senior Specialist and Secretary to the Board. Matt Pleasant is the current Planning Administrator. The Board has copies of the zoning ordinances that will be incorporated by reference into the record of each case heard today. The proceedings of this hearing are governed by the Board's rules of procedure. The expedited cases will be heard immediately after all requests for continuances or withdrawals. As each non-expedited case is called, petitioners and remonstrators interested in that particular case will please stand. Those who intend to testify will please remain standing and be sworn. Petitioners should be on your left and remonstrators on your right as you face the board. Those who testify will state their name and addresses for the record before beginning to testify. Petitioners and persons appearing in support of the case being heard shall have a maximum of 15 minutes for the presentation of evidence, statements, and arguments in support of the petition. Remonstrators and persons appearing in opposition to the petition shall have a maximum of 15 minutes for the presentation of evidence, statements, and arguments in opposition to the petition. Staff will then present the administrator's comments regarding the petition. The petitioner will then be allowed 5 minutes for rebuttal and a submission of the case. Rebuttal must be limited to the subject matter of the initial presentations. Remonstrators will then be allowed 5 minutes for rebuttal of the petitioner's rebuttal evidence and a brief closing statement. No further evidence, statements, or arguments will be heard unless it is at the discretion of the board. Please limit your testimony and evidence to the matters covered in the statutory requirements, which must be met in order for the board to grant a variance. If the petitioners have failed to comply with all notice requirements as stipulated by the board's rules of procedure, including posting of the notice sign on subject property at least 23 days prior to the hearing, the board may continue the petition. Anyone at this hearing who thinks complete and proper notice has not been given and would like the petition continued for due to lack of proper notice must bring this matter to the board's attention at the beginning of the hearing. The board may impose various conditions or comments or commitments as amendments before reaching a decision on certain petitions. The installation of landscaping and screening, the paving of a parking area, and the dedication of rights-of-ways are examples. These conditions and commitments are an integral part of the board's decision and must be met for a granted variance to be valid. Compliance with conditions imposed by the board must be proved by an affidavit of compliance submitted by the petitioner within 30 days of completion. Unless otherwise specified, an improvement location permit must be obtained prior to the establishment of the authorized improvements. Excuse me, sir. Will you wait till I'm done reading? Thank you. Failure to comply with any conditions or commitments a variance grant is a violation enforceable by Department of Business and Neighborhood Services. A person may file a written request to receive notice of the filing of a petition for judicial review of the decision of the board. The written request must be filed within 5 days of the board's decision and must include the person's full name and correct mailing address and a reference to the board's petition number. Forms are available and may be obtained from the board secretary. Please be advised that contacting members of the board regarding a matter pending before the board outside of the public hearing process is prohibited. Please be courteous and orderly at all times, and please be sure all cell phone ringers are turned off. Please note that there are only 3 members present today. Your request will need 3 votes to take action on a request. If an indecisive vote occurs, your petition will be automatically continued to the next hearing of the board. We will take this into consideration when hearing special requests. Is there anyone in the audience who has any questions about our procedures? If not, before we hear special requests, I will ask for a waiver of our rules of procedure to allow the board to vote for all expedited petitions and adopt their findings of fact without any additional testimony from the individual petitioners. May I hear a motion to do so?
Brandon, so moved.
Thank you. And do I hear a second?
Farmer, second.
Thank you. I will now ask for the vote. Brandon?
Yes.
Farmer?
Yes.
And I am a yes. We will consider special requests and continuances at this time.
Good afternoon. My name is Bill Meemeyer. My address is at 6910 North Shadeland Avenue, Indianapolis, Indiana, 46220. I am here this afternoon because I represent the petitioner under cause number 2022 UV2 014, and I would like to make 2 requests, if I may. First, we would like to withdraw this petition because it is a petition seeking use variances, and we've determined that there are some existing commitments and instead of asking for a use variance, I need to ask to modify the existing commitments. So I'd like to withdraw the pending petition, and related to that withdrawal, in speaking with staff, I am requesting that a portion of the original filing fee be transferred and applied to the new petition that I will be filing. And when we filed, we paid a filing fee of $2,084, and the amount of credit that we are requesting is $1,108. And so those are my two requests. Thank you.
Okay, first of all, we acknowledge your withdrawal. Second, as to the credit, is there anyone else in the audience with an interest in this petition, number 2022 UV2-014, with addresses 6333, 6345 West Thompson Road? I doubt it. Okay, comments from staff on the credit.
Thank you, Chairperson Von Dalen and members of the board. Staff did speak with the petitioner and is supportive of the transfer of partial fees to the newly submitted petition with a total of $1,108.
Very well. Do I hear a motion to allow the transfer of the credit to a new case?
Brandon, so moved.
Thank you. And a second?
Farmer, second.
Thank you. I'll call the roll. Brandon?
Brandon, yes.
Farmer?
Farmer, yes.
And I'm a yes.
Thank you very much.
Welcome.
Thank you, Mr. Von Dillon. My petition today, 2022 DV2, excuse me, 022 at 1342 East Street. We're asking for a continuance. Staff has recommended denial or us to engage some changes. The architect of record did not have time to prepare those drawings for the hearing today. So we're just asking for a continuance to your next scheduled hearing.
Madam Secretary, what's the date of our next hearing?
That would be July 12th.
July 12th. And that is with or without additional notice, Mr. Crouch?
Without notice.
Very well. Is there anyone else in the audience or in attendance of the meeting that has an interest in petition number 2022 DV2-022 with an address of 1342 Southeast Street? None being seen, we'll go to comments from staff.
Thank you, Chairperson Von Dalen and members of the board. Staff has no objection to the continuance for this petition to the July 12th, 2022 hearing date without additional notice.
Thank you.
Thank you.
I'll entertain a motion to continue to our July 12th regular meeting without additional notice, petition number 2022 DV2-022. Do I hear a motion?
Brandon, so moved.
And a second?
Farmer, second.
Thank you. I'll call the roll. Brandon?
Brandon, yes.
Farmer?
Farmer, yes.
And I am a yes.
Thank you.
As there are no other special requests, go to staff.
Chairperson
This Von Dalen, Mr.
Von Dalen,
Ewing.
my apologies. I'm not sure where I was. Thank you. Chairperson Von Dalen, members of the board, staff will draw your attention to petition number 2022 UV2009, located at 1251 West 96th Street. Petitioner has filed a timely automatic continuance for this petition, continuing it to the July 12th, 2022 hearing. This would just require your acknowledgement.
Acknowledged.
Thank you. Following that, staff will draw your attention to petition number 2022 UV2-010, located at 2400 Roosevelt Avenue. The petitioner has filed a timely automatic continuance for this petition as well, continuing it to the July 12th, 2022 hearing. This would just require your acknowledgement.
Acknowledged.
Thank you. Finally, following that again, staff will draw your attention to petition number 2022 UV2-011, located at 1355 West 96th Street. Petitioner has filed a timely automatic continuance, continuing this petition to the July 12th. This would just require your acknowledgement.
Acknowledged.
Thank you. Continuing down under new petitions, petition number 2022 DV2-017, located at 928 Woodlawn Avenue. The registered neighborhood organization has filed a timely automatic continuance for this petition, continuing it to the July 12th hearing, requiring your acknowledgement.
Acknowledged.
Thank you. And Petition number 2022 DV2-020, located at 1603 Hoyt Avenue. Registered Neighborhood Organization has filed a timely automatic continuance for this petition, continuing to the July 12th, 2022 hearing, just requiring your acknowledgement on that as well.
Acknowledged.
Thank you.
Chairperson Von Dalen and members of the board, staff would draw your attention to petition 2022-UV2-012 under the continued petitions portion of the docket. A timely automatic continuance was submitted by the petitioner, continuing this to the July 12th, 2022 hearing date, and that would require the board's acknowledgement.
Acknowledged.
And following that, staff will draw your attention to petition 2022-UV2-013 under the new petitions portion of the docket. Address at 6111 West Hannah Avenue. A timely automatic continuance request was submitted by a registered neighborhood organization, continuing this matter to the July 12th, 2022 hearing date, and that would require the board's acknowledgement.
Acknowledged.
Thank you.
Thank you, Chairperson Von Dalen and members of the board. Staff would draw your attention to 2022 UV2-007 for 1259 West 29th Street. A remonstrator has filed a timely automatic continuance request, continuing this to the July 12th hearing. This would require the board's acknowledgement.
Acknowledged.
Lastly, from me, 2022 UV2-016, 2505 North Sherman Drive. A registered neighborhood organization has filed a timely automatic continuance, continuing this to the July 12th hearing date. This would require the board's acknowledgement.
Acknowledged. Sounds like we may have a busy agenda next month. Is that all from staff? Thank you. We will now proceed to the expedited docket specialist.
Before I begin with the expedited docket, could you poll the audience and see if there's anyone here in opposition to petition 2022 UV2015?
Is there anyone in the audience with an interest in or in opposition to a petition number 2022 UV2-015 with an address of 3725 Kentucky Avenue? We're here. Come to the dais, please. Give me your name and address.
My name is Linda Hartsala, address 3640 Olinder Drive, Indianapolis 46221.
Very well. And you are, this petition is set up to be on our expedited docket. Are you in opposition to this petition?
No, I just wanted to see what it was about.
Oh, so you were just looking for information. Do you have any
I've got
objection?
the yellow paperwork here.
Yes, ma'am. Do you have any objection whatsoever to it being continued on the expedited docket, which means there will be no discussion and it will just be voted on?
Yeah, that's fine.
That's fine. All right. Very well. Thank you very much for appearing. Madam Secretary.
Thank you. 2022 DV2-018, 1805, 1817 Sugar Grove Avenue, Center Township, Council District 11, Zone D5, W1, Onyxon East, LLC by Lauren Wall, requesting a variance of development standards of the Consolidated Zoning and Subdivision Ordinance to provide for a single-family dwelling and detached accessory structure with vehicular access from Sugar Grove Avenue, alley access required. 2022 DV2021, 1720 through 1744 North Illinois Street, 1715 Hall Place, Center Township, Council District 11, Zone MU1 in Regional Center, TOD, Arrow Street Development, LLC by Peter D. Cleveland, requesting a variance of development standards of the Consolidated Zoning and Subdivision Ordinance to provide for driveways to Illinois Street and 18th Street that are 22.5 feet and 24 feet wide, maximum 16-foot width permitted. 2022 UV2015, 3725 Kentucky Avenue, Decatur Township, Council District 22, Zone C1, Babak, LLC by Hassan Mihanka, requesting a variance of use of the Consolidated Zoning and Subdivision Ordinance to provide for consumer services or repair of consumer goods not permitted. That is the end of the expedited docket, Mr. Von Dalen.
All right, will the petitioner or petitioner's representatives please step forward? Do you want me to have them state their request considering we're doing this?
No, is that what it says in the?
Yeah, there's no real other necessary presentation, but we'll go ahead and cast our ballots. There, I may have shuffled mine. Shuffle.
2022 DV2018, 2022 DV2021, 2022 UV2015, 3 votes cast, 3 yes votes. All expedited petitions are approved. However, petition 2022 UV2015 will be continued for the submittal and adoption of revised findings of fact in support of the board's decision. With that, everyone on the expedited docket is free to go.
Thank you. We'll move on to our regular docket.
Thank you.
(2022) DV2019, 914 St. Peter's Street, Center Township, Council District 17, Zone D5, Farfallina Properties, LLC by Mark and Kim Crouch, requesting a variance of development standards of the Consolidated Zoning and Subdivision Ordinance to provide for a duplex on a 40-foot wide, 5,000 square foot lot, 60-foot lot width, 7,200 square feet required, with a 7-foot front setback, 10 feet required, and 50% open space, 60% open space required, and a single-family dwelling with a 7-foot front setback, 10 feet required. All persons speaking on this today, please step forward to be sworn in. Do you solemnly swear or affirm under the penalty for perjury to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please state your name and address for the record.
My name is Mark Crouch. My address is 124 East Pleasant Run Parkway, Indianapolis, Indiana, 46225. The request before you today is for 914 St. Peter's Street. It is currently, I believe, 1 lot, but it has been approved to be split into 2 lots. Originally, there was a duplex that was on the southern portion of the lot that was destroyed during redevelopment by a wind gust. And so we've had to go through the process of having that legally demolished, and the insurance company basically has issued their I guess the reward or the policy coverage for the tenant under the stipulation that it be reconstructed as the original duplex or as close to it as possible. So that's the purpose of the variance today. Staff is recommending denial because the duplex, although it was previously there, I guess there's enough difference in what we were trying to do, which was basically readjust it so it wasn't no longer hugging on a property line. And there was a detached garage that crossed over the property lines. It was larger than the one that we were intending to rebuild, but because it was across those property lines, that married those 2 lots together. We have also demolished that garage so that each parcel would stand alone. The proposal for the duplex, although it's very similar, it is a little bit different in its location because we wanted to maintain a distance away from the adjacent home, which kind of straddles the property to the south. The owner is in a little bit of a particular situation to whether she probably would prefer a single-family home, but because of the insurance policy and the existing duplex that she purchased, that's kind of tied to her claim. So the hardship would be financial hardship, which maybe sometimes is not a case, but in this case, we would have to go back to the insurance company and open that up. There was a duplex there originally, so I don't think that the spirit of how the property is developed has changed in any way. It would be for single family, but that's also very consistent. There is a duplex that's across the street from us, and I believe there are a couple more that's in the immediate area. With the additional lot that's created, she is wanting to build a single-family home and actually sell that to kind of recoup the losses that she's had of income and the cost of demolition, new water and sewer line and those things. So we weren't able to reach an agreement with staff. I don't think for any reason other than the code just would not allow them to agree to this. And I agree with that. I wish there was a way that we could have had a compromise there, but we don't have one. As of yet, we'd be willing to listen to one, but I think that the fact that there was originally a duplex there and we're attempting to reconstruct it similar to what was there, had always been there, we would ask for your guys' approval. I think that's pretty much covers it. If you had any questions, happy to answer.
All right. It's an interesting predicament. The duplex, the original duplex, I mean, you've shown on your drawings where the garage was. Where was the original duplex? Did it straddle the property line as well?
And actually, it did not. It was closer to the southern property line. Okay. So we tried to put it back in the center to create more separation from the other structure. So they were a little bit closer, I believe, than what we're proposing.
Okay. I cannot read the dimension for the depth of the garage on this particular site plan. Can you tell me what that is, Mr. Crouch?
I believe it's 22 feet.
Okay, very well. Do any of the other members of the board have any questions for the petitioner? Nope. All right. I would poll the audience, but you are the audience, so there's no one else here. So we'll go to comments from staff. I have a feeling it's Mr. Uhlenhake is ready to go.
Thank you, Chairperson Von Dalen, members of the board. A little background. The subject site is comprised of two original platted lots, lots 23 and 24, in the Myers First Edition platted subdivision. According to the assessor's records and aerial photos, the subject site was developed in 1901 with a duplex on lot 23, which was ordinance compliant at that time. And then with a two-car garage straddling the center lot line added later in approximately 1961. Other than for a portion of the two-car garage, lot 24 appears to never have been developed and was just used as a side yard for the duplex. When the petitioner filed the petition, he made no mention of the house being demolished by the wind or insurance issues. That was brought to staff's attention after staff gave their recommendation to the petitioner. If that is the case, then no variances are needed for the petitioner to an extent, because a two-family dwelling demolished by natural causes can be rebuilt 100%. It would be considered legally non-conforming to be rebuilt as was 100%, unless it had been vacant for a number of years or the site, the plan is altered, which I believe is the case in this situation. That alteration is that the house was originally developed on one parcel, although two lots, it was developed on one parcel. And now they want to develop the lot on two parcels. They want to develop both parcels. They want to split the lot and develop both lots. They want to split the parcel, develop both lots separately, as well as not originally developed with the original two-family dwelling that was demolished. Since they are altering that, then I believe they do lose the legally non-conforming use, which is why they're here probably asking for variances, because they also want to redevelop the second lot with the single-family dwelling, and that makes the original lot with the duplex non-compliant because they lost their non-conforming status, if that makes sense so far.
Kinda.
In that regard, staff has no problem, and they are legally, and repeating myself, they are legally entitled to rebuild the dwelling as was originally built, but that legally non-conforming use does not allow them to build the duplex unless it is legally, unless it is ordinance compliant, which it is, their request is not. Since their request does now provide for both a single-family dwelling and with the 7-foot front setback, which is deficient, although the lot is not deficient for the single-family dwelling, and the duplex, which is on a deficient lot, a 5,000 square foot lot, where a 7,200 square foot lot with a lot width of 60 feet is required, and they're only providing 40 foot, excuse me. There's nothing wrong with the subject site to keep it from being developed, as both a single-family dwelling and a multi-unit dwelling are permitted by right on both lots and can be developed as such without variances. And since both lots are existing are vacant, staff believes there is no practical difficulties for them to be developed. None have been provided by the petitioner other than the house being demolished by wind, I believe, and needs to be rebuilt for insurance purposes, which could still be done as was originally built, using both lots as a single parcel. And with both lots being used for the duplex, the lot does become ordinance compliant, and no variances would be needed for that. However, when you do split the lot, the parcels into two lots, that is when when variances are needed for the deficient lot for the duplex, if it is not being built as a legally non-conforming use, which apparently it is not. Since staff believes these are self-imposed and there is no practical difficulty with the lots as being developed, staff is recommending denial of the petition. Be happy to answer any questions or provide clarification if needed to the board.
Okay, I've got some questions. So, if this duplex was blown down by the wind and they just wanted to rebuild it on that lot that it was located on, they could do that right now, and they would not need a variance, correct?
To my knowledge, correct. If they built it as it was originally built, yes.
If they built it as it, the site itself was originally platted as two lots, correct?
Correct.
It was then parceled together into one property.
Correct.
When it was originally platted, would it have been legal for them to put a duplex on one of the lots?
Yes, because the original duplex was ordinance compliant, as was the duplexes across the street that was mentioned by the petitioner.
Right, and they would have still been able to then build another single-family house or even a duplex on the lot to the north as well at some point?
Correct, yes.
Based upon the original plat?
Yes.
Okay. If the duplex had not been blown down by this terrible storm, would the property owner then have been allowed to build a single-family residence on the additional lot that was originally platted there without a variance? Remember, it is a platted individual lot, even though it is parceled together into one parcel.
Presuming the garage would have been removed since
yeah, presuming the garage is removed.
Yes, they would have been able to build a single-family ordinance compliant on the north lot.
Okay. Thank you. And then the other question is, did the members of staff and the principal planner take into consideration the shortage of housing that we have in Indianapolis when they decided to recommend denial of this petition?
I believe we take that into consideration with every petition, yes.
Thank you. All right, those are my questions. Thank you, Mr. Uhlenhake. I think I understood everything, but that's pretty thick. So, all right, go ahead. Any other questions from members of the board?
Chairman Von Daly, may I add a comment just to staff's comments?
Sure. Thank you, Mr. Voice of God from way back there. Thanks. Go ahead, Eddie.
I just kind of wanted to address your point about whether or not staff takes into consideration the housing shortage, and the simple answer is that yes, we do.
Yeah.
And through the changes that were implemented back in November, while there is a perception that we've made it more difficult to build duplexes, I would push back on that a little bit. I think we actually allow it in more districts than we historically have, but we've also introduced more housing typologies that do allow for more density within the same amounts of land, and in fact, smaller tracts of land that are required for duplexes, namely in the form of multi-unit homes and opening up development of row homes. So I would just like to add into the record that we have added more land uses in an effort to address that circumstance that goes beyond just single family or two family, which has historically been your options in urban forms.
Thank you, Mr. Onea. The only thing I would say, though, and I agree with you, and I think you guys are doing a great job. Originally, as this property was platted, there could have been 4 residential units on these 2 lots. And right now, we're trying to get the petitioner's trying to get a variance just to put 3 on these lots. So that's kind of where I'm kind of trying to understand it. So, any other questions for staff or members of the board?
The only question I had is on the setback requirement and the open space requirement. It appears by the plot plan that you kind of presented here. Can you kind of explain why you're not able to meet the requirements under the code? Because it appears to me that those are kind of self-imposed, that maybe adjustments could be made in terms of the setback in the front and in the total lot, depending upon the square footage.
With regards to the square footage of the lot, we could probably make some adjustments there. I think the biggest issue comes up with the width of the lot, which it would not be allowed. Maybe the next revision in the code will take that into consideration. It certainly should, I think, was missed, and it is glaring.
So really your big issue, sorry to interrupt, your big issue is the width of the lot and the fact that that lot width will not accommodate, according to the current ordinance, a duplex.
Correct. And staff made perfect comment when it was one lot, one ridiculously large lot, which is, in my opinion, bad land use for where it's located and what we're trying to achieve. It would be fine. But that's not good planning. So I think this is a better plan, and I would agree that we made some changes which eliminates the grandfather aspect. Those changes are to make the square footage of the property a little more affluent, makes it more functional for today's society. It allows for a family use probably versus a single person. So I think it helps bring more to the neighborhood. The other part was by adjusting it to the center of that lot, we also lose that exception. We also bear the cost of the expense for that. So we could have built that structure and then separated the lot, got around all of this, not came here, but coming here in a way, it did 2 things. It allowed us to meet the requirements that the insurance company placed on the homeowner, and it allowed me to bring some concerns with the plan that was well thought out and still needs thought out, and it brings that kind of to the forefront. We risk losing being able to do this, but it is correct. We could go back and build closer to the property line, a smaller duplex that doesn't really meet the needs of the community, and it's not as much, I think, of a it meets many users can use this now. Mother-in-law, a larger family, lots of things. I think it's a better structure.
Well, we got you talking, and this isn't really taking away from your time, but you've been pretty brief anyway. How critical is the 7-foot versus 10-foot front setback to you?
We were, original conversation, we were okay to eliminate that. We just felt that with children, that street's kind of like a turnaround, so it gets it's actually not constructed, I would say, the way it should be. There's no cul-de-sac at the end. It's so we felt like sliding it back a little bit would give more of a front yard. We wanted people to be out into the front yard instead of kind of stuck in the back. So that's why we slid it back. But we could move it up, but I don't know that there's any aesthetic difference to it, and I think it just gives a little bit more space in the yard for.
So I'm confused. I mean, we're not asking you, I'm saying, can you move it back to 10 feet versus the 7 feet that you have indicated on your drawing for the front setback?
Oh, yeah, we're totally fine with that.
You're fine with that?
That is correct.
Then what about the concept of trying to accommodate the 50% open space requirement? Is that a no-go, or is that problematic for you guys?
So my other opinion on the 50-foot is that the overhangs contribute to that. We could eliminate the overhangs.
You mean 50%?
Correct. If we eliminated the overhangs, I think we would be a lot closer, but you don't really end up with a better structure. And
wait a minute. And I'm going to ask this of staff. When you guys calculate open space, you calculate to the eaves as opposed to the walls of an individual structure? Mr. Onea, what's the answer on that?
That has fluctuated in the past because we believe permits was doing it from the eaves, but now I believe it's to the walls.
Oh, okay, to the walls.
I've spoken with BNS about this recently, being this calendar year, and it's essentially been stated that the footprints are calculated rather than the overhangs.
Okay, that would be good, because it seems kind of unfair to calculate the eaves, because those could be crazy small. I mean, or the developer might be just get rid of the eaves so I can get more space. Okay, that makes sense. And sorry, Mr. Onea, when you're talking, I can't see you physically. So when I say the voice of God, it literally seems like the voice of God is coming down. So.
I understand. Thank
All
you.
right. Back to staff. If the petitioner were to acknowledge and accept that they needed a 10-foot setback and tried to get closer to the 50% open space versus, 60% open space versus 50% open space, would that change the opinion of staff as far as a recommendation for denial?
Staff's position is collective and not mine singularly, so it'd be hard for me to interpret what other staff members as a collective voice would feel on that. Generally, I think we would not be supportive of that on the face of it, because we believe this can be developed either with 2 single-family dwellings on each lot with accessory dwellings to the rear for 4 units, or a duplex to provide if the duplex has to be rebuilt, or as stated previously, a small multi-unit house that provides for 4 units. If the number of units is the issue, there are ways to accommodate that. If rebuilding the duplex is the issue, which was not presented to staff in the petition, there's ways to accommodate that as well. So I believe staff would continue to say no. Regarding this front setbacks, staff objected to that because both of the dwellings to the north and the south are at 10 feet as well. Both of these proposed at 7 feet would stick out in front of those.
Yeah, that's what I saw.
So if the petitioner is withdrawing this, staff would request the board acknowledge that withdrawal for both of those. Thank you.
Okay. Would the petitioner consider withdrawing the request for the 7-foot setback versus 10-foot setback?
Yes, we would agree that is probably just an oversight. I think we would prefer that.
So you would withdraw that?
Yes, and I think that we automatically would have about a 5% reduction or increase in open space if we didn't calculate the overhangs, which are calculated in that open space, so we would be at 55%. And I would be happy to modify that.
So you would amend your
petition
to, instead of 50%, to 55%?
Yeah.
And you're good with that?
Yes, totally.
Okay, because I'm going to...
Because we included the overhangs.
Okay, all right. Any other comments we're actually in the staff comments portion of this case. Any other comments from staff before we go back to rebuttal? Because Mr. Crouch still gets 5 minutes of rebuttal at this point.
No, thank you for the offer, and staff has no additional comments in regards to your questions.
Thank you, Mr. Uhlenhaken. Unless there are any other questions from members of the board? No? All right. You have 5 minutes.
Okay. To talk about the November 1st, the new plan I think is fantastic. And I think the object is fantastic. Just a little bit of tweaking, which I think normally would happen with everything. You can't get it.
Actually, you're only supposed to be talking about this case, but that's fine.
And then with amending our petition, I believe that if we would have had time with staff, and we would have, I think staff probably would be recommending approval today.
Okay.
And with the second property being the single-family residence, I think it helps the owner. I think we've established the hardship to a certain extent, I would think, not 100%, I guess. I would agree with that. And I think the original intent for the duplex, it stays the way it was originally constructed. I think there's an extra family that's going to be able to enjoy the area that would probably be locked out. And I think the owner will have a piece of property that's self-sustaining, and it's an asset for the community.
Okay, thank you, Mr. Crouch. That being said, I will call for the vote. Yes, Madam Secretary?
I just want to confirm that you have acknowledged the amendments to the request.
That was what I was going to do, but that's fine.
Well, and I would like to know if that is in fact for both of the 7-foot front setbacks.
Yes.
I'm okay with that. We want more room in the front.
So, okay, so you acknowledge that you have withdrawn your request for a 7-foot front setback on both of these properties,
Correct.
and that you have committed to 55% open space on this particular property as it pertains to the duplex if you are awarded this variance.
Correct.
All right, very well. Anything else, Madam Secretary?
That is all.
Okay,
Thank you.
then I'll call for the vote. You may fill your cards out now. Oh, we can't do that.
Oh, that's right, we can't
Yeah,
pass
we're
them
not
down.
allowed to touch each other's ballots.
Yeah.
State law. Which, by the way, it's an ordinance violation, not a code violation, Mr. Crouch. Let's make sure we get that clear. I want to make sure we're on. Yeah, I'm a stickler for this.
Noted.
So a vocab quiz is coming?
What's that?
A vocabulary quiz is coming up next?
Yes, we're going to have a vocabulary quiz. We do.
We do,
Is this a long month? Oh, August. Okay. A blue moon month.
2022 DV2019, 3 votes cast. Farmer voted yes. Von Dalen, yes. Brandon, yes. 3 yes votes, 0 no votes. This variance is approved.
Thank you. Thank you, staff, as well.
Considering there's no one else literally here, is there any other do we have any additional business today?
Mr. Steinmetz provided me with negative findings of fact for a petition heard at a previous hearing and denied by the board. Board member Deckett Brown is not here, but otherwise I can collect Brandon and Farmer's signatures on these findings, and then I do have findings for today.
Excellent.
With that, I have no additional business.
All right, let's all be careful going from this incredibly cold room to the incredibly hot outside, and don't pass out or something like that. We're adjourned.